Good morning, and thank you for joining me on this week's Thursday morning coffee break with DCE Law. My name is Deborah Sermonaro Eldridge, and I am the owner and attorney for DCE Law, and I'm coming to you each Thursday morning with tips and information regarding certain topics. Those topics, for me, that I practice in are business startup and family law. And today, following up on our live from last week, we are talking about child custody and divorce, as well as child support situations. Now, it doesn't just have to be in divorce, because sometimes parties never get married and they still have child custody and child support issues they have to deal with. So what I'm going to tell you today has to do with situations where paternity and custody are at issue, as well as obtaining a dissolution of marriage involving children. In the state of Florida, when it comes to child custody, we start with the presumption that each parent has a right to be equally involved in their child's life. And that is because a child benefits when both parents have equal time sharing with the child, or are equally involved at the very least in their child's lives, as long as both parents can have a nurturing, structured, and loving relationship with the child that will not be detrimental in any way to the child. So we always consider the child's best interest when we are looking at custody situations. So speaking of the child's best interest, and starting with the presumption of 50-50, we look at the situation based on what parent has been most involved in the child's life, as well as what would be best for the child from a time-sharing perspective. While both parents want that 50-50 time with the child, or to have as much time as possible with the child, we also have to look at other conditions and considerations when we are talking about what is in that child's best interest. For example, if one parent has been the primary residential parent and the other parent has actually been traveling for work, has a job that takes them away from the family in-house for days at a time, maybe depending on what their schedule is, even if they're locally, they may have times where they have to be at their place of employment overnight for a specific period of time, maybe 3 days, maybe 4 days, whatever it is. Or they might have a work schedule where they are working 3 to 4 days a week in a row, and they're working long shifts, such as 16-hour shifts. And so we have to consider that, because obviously if that's the other parent's schedule, an equal time sharing may not work out the way that parent would like it to. But then we also have to consider, well, if that parent has 3 days off a week, how can we structure that so that the parent has the benefit of having time with the child as well? So we have something called the parenting plan. And what the parenting plan does is it helps us break down time sharing with the child. It governs this child's weekly schedule, as well as vacations and holiday schedules, as well as birthday schedules. It also addresses the communication aspect of the parties and how the parties and the child will communicate. It's very important that both parties maintain, to the extent possible, a good working relationship for the benefit of the child. Does that mean that you're spending the night at the other parent's house? No, that's not healthy. Once you are separated, you're separated. Once you're divorced, you're divorced. That sends the child to mixed signals, and it also leads to an unhealthy relationship between the parents of the child when they are actually supposed to be separated. So, but what that does mean is you can still share birthdays together. You could share holidays together if you have that kind of a working relationship. You can attend school functions together. You can attend extracurricular activities, and you should be able to call one another. Not every situation is like that, of course, but you should be able to call one another when something regarding the child is at issue, whether it's their health, their education, where they're attending school, or whether the child wants to be involved in certain extracurricular activities, as well as how those are going to be addressed from a financial standpoint. So when we look at custody, we start again with the premise that time sharing should be 50-50, but that can't always be the case. It also cannot be the case if, in fact, one of the parents has a significant illness, such as an addiction to alcohol or drugs, or something else that would put the child in harm's way if the child were in the unsupervised care of that parent. In that situation, we might have to look at sole custody for the parent who is in a better position and healthier position to care for the child. We also have to look at factors such as the child's situation. Is the child special needs? Does the child have health issues that require attention and care that perhaps can't be transferred easily from one household to another? So we have to look at those conditions as well. Once we have addressed that situation, we can also look at whether it's where the parties are in a place where one parent can have the child more, but the other parent can have time sharing, even though it's not 50-50 with the child, such as every Tuesday and Thursday overnight, or every other weekend overnight, depending on, again, on that parent's work schedule and what will allow that to happen, as long as that other parent is in a healthy situation for themselves. So that's how we look at child custody and determining what is in the child's best interest. It's always best if the parties can agree to a time-sharing schedule that is going to promote a healthy, loving relationship between each parent. Sometimes, again, that's not the case, and then we have to look at how we can tailor time sharing so that we are taking care of the child, protecting the child's best interest, but still allowing both parents to be involved in the child's life. Now, moving away from child custody, we then look at child support. Child support are based on what we call child support guidelines. This is statutory. A child's right to child support inures to the child. In other words, the child has the right to be maintained in the standard of living the child had during the course of the marriage or relationship of the parents, to the extent that that is possible. So we look at that, and we take the party's net income, and then based on that net income, we go to the child support guidelines. On a monthly basis, we figure out that net income, and we go to the child support guidelines, determine what the guidelines are based on 1 child, 2 child, 3 children, and then we take that amount, we divide it in to each parent's net income to come up with that parent's percentage of child support that they would have to pay. Then what we look at is any special needs of the child, health insurance of the child, anything that would have to be added into that calculation. And again, we look at the percentage of each parent's obligation in supporting that child. If the situation is a 50-50 time sharing between the parties, we have to do an additional calculation. And that calculation takes into consideration that both parents are going to have equal time with the child. So then we have an additional calculation, and what we do is, in the end, we subtract the lower amount from the higher amount of the child support, and the amount that's left for whichever parent it is, that parent has to pay that amount to the other parent. Sometimes there may be very little to nothing left. So that's how we calculate child support. But if we don't have a 50-50 time sharing, if we have sole custody, we can actually add an additional amount to that because that parent has all the financial responsibility for the child. If we have a split with regard to it's not 50-50, and based on the parent's work schedule, whatever it is, or the decision of the parties, then what we do is we stop our calculation before we have to do the additional 50-50 calculation, and we determine the guidelines amount based on whichever the support amount works out to. For example, let's say that it's $1,000 a month child support obligation for one child, and the non-residential parent has a 55% obligation. That means that parent would have to pay $550 to the other parent on a monthly basis. That's how that works. So that's the down and dirty, behind the scenes, behind closed doors way that we go ahead and, pursuant to Florida statutes, calculate out child support and determine child custody that is always in the child's best interest. Thank you for joining me today. I hope everybody has a wonderful rest of your Thursday. Please follow us on YouTube, DCE Law. We're under DCE Law. That is our channel. And then please also check us out on Instagram at DCE Law and watch for these weekly videos. Thank you.